Hey, I'm Logan Butler, and I'm a partner in the law firm of Patterson Moore Butler. One of my specialties is criminal defense. I've been practicing in criminal law my entire career. Started out as an assistant district attorney prosecuting cases, and now I defend all sorts of criminal cases. I've also taken the same class that law enforcement officers have taken to learn how to detect DUI drivers and conduct field sobriety tests. So I know what the officer is supposed to do, and I know what the officer is looking for. So at the start of a DUI case, we're going to look at why did the officer pull you over? Did they have a valid reason to pull you over? Remember, all the officers now have cameras, either one on their chest and one in their car. So everything you do and say is being recorded. And that could be evidence that could hurt your case, or it's evidence that we can use to defend your case. So everything's being recorded. Just keep that in mind. The officer is doing them to try to get evidence against you, evidence to show that you should not be driving. Now, when I look at this test, I'm not only looking at how you performed on the test, but I'm also looking at how the officer instructed you to perform the test. They're standardized for a reason. There are certain things the officer must do in instructing you, certain ways to score the test, and they don't always do that right. So we look at those to find ways to defend your case. Now, if you agree to submit to this test, they'll take your breath, usually at the jail, or they'll take you somewhere to have a nurse draw your blood, to have it analyzed. If your result comes back higher than 0.08, that's considered a DUI per se. So long as the test was done correctly, your blood was drawn by the proper person, the testing equipment was in proper working order. These are other things we look at in trying to defend your case for you. Now, if you refuse to submit to that test, the officer most likely took your driver's license from you and gave you a yellow piece of paper known as a 1205 form. Now, this is something separate from the criminal DUI charge, but in refusing that test, the state of Georgia is going to penalize you by administratively suspending your license to drive for 12 months. Now, we have some ways to fight that. The important thing to know is in addressing the ALS, or administrative license suspension, we have to do something within 30 days of your arrest. If you miss that 30-day time window, your license is going to get suspended for 12 months no matter what we do. So it's important to come in early, come in as soon as you can after your arrest so we can look at your case and look at how we're going to defend an administrative license suspension if you're facing one. We'll look at your DUI case. We'll look at what the officer did. We will find out if he made errors in the case, so we can file motions to suppress or motions to defend your case. There's a lot to look at, a lot to consider, and that's why we're here. This is something that we've done for years, and if you're facing a DUI charge, we would love to help you out.